Hello, everybody, and welcome to our 2025 Year in Review webinar for trademarks. My name is Kwan, and I'm a principal in the trademarks group of Smart and Biggar, based in our Vancouver office. I'm just going to move the slide so that you can see our presenters today, even though I'm sure you see us all on screen anyway. I will be moderating today's webinar, so I've got the easy job today. I'm very excited to introduce our presenters for today. We have Toba Cooper, an associate in our Toronto office, Karl Racine, an associate in our Ottawa office, and Jennie, a senior associate in our Toronto office. Before we get going on content, just a very quick word about who we are. I'm sure most of you know, but Smart & Biggar is Canada's leading IP firm, specializing in all types of intellectual property. So be it patents, trademarks, copyright, enforcement, or litigation, we have it covered, and we think we're the best at what we do in Canada. Our team is thrilled to be sharing our insights with you today. For those of you who have attended our Trademark Year in Review webinar in the past, it's a bit of a change this time around. We've taken a different approach by looking at different themes which have shaped trademarks in Canada in 2025, as opposed to a case study approach which we've taken in the past. We hope that after our presentation today, you'll be left with a sense of the big picture developments that have taken place over the past year in trademarks in Canada in 2025. Before we dive into the content itself, just a couple of housekeeping details. For our formal presentation, we're aiming for about 50 minutes, and that will be followed by an open and interactive Q&A session where we will address more specific questions you may have. You're welcome to submit questions at any time during the presentation by clicking on the Q&A panel at the bottom of your screen. We'll try and address as many questions as we can during our live session today. If you require live captions in French, please turn on Show Captions in the Zoom toolbar, select Translation, and choose French Canada as your caption language. Please note this webinar is being recorded. You will receive an email with a link to the recording, along with a PDF copy of the slides following the session. And finally, at the end of the webinar, a survey link will pop up. We'd appreciate if you could take a moment to share your feedback with us on today's session and let us know what other topics you're interested in learning about in the future. Without further ado, I will now turn it over to Toba to kick off our presentation.
Thanks, Kwan, and thanks to everybody for being here and taking the time to join us. Over the next 45 minutes or so, we will review developments in Canadian trademark law from 2025. The decisions, legislative updates, CIPO initiatives, and procedural changes from the past year reflect a system continuing to adapt in the wake of the 2019 amendments to the Canadian Trademarks Act, particularly with respect to the removal of use as a pre-registration requirement. By the end of last year, a substantial number of applications filed under the post-2019 framework have actually moved far enough through the system to trigger and reveal downstream effects of the changes. What's perhaps particularly interesting about this moment in the world of Canadian trademarks is that the timing of the impacts of the amendments are surfacing and uniquely coincide with a post-pandemic commercial environment marked by cross-border trade pressures, rapid adoption of artificial intelligence, and increasingly complex digital marketplaces. 2025 updates and decisions reveal a system working through the practical consequences of the new model that doesn't require use to achieve registration. Today, our hope is to focus on how core concepts, old and new, like use and non-use, special circumstances, and bad faith, are being applied today. We tend to highlight some noteworthy trends as we settle further into the post-2019 regime and discuss how some of today's unique market realities are beginning to shape this chapter of Canadian trademark law and practice. So we'll move into the overview then so that you'll get a sense of where we're headed. and what we intend to cover. Not all of the cases we're going to be discussing are in this slide, so you'll have to go back and click through our presentation once you receive a copy at the end of the webinar. But as Kwan said, you will see that we've taken a thematic approach this year. And so why don't we move right into the SIPO update? Because, well, in addition to key practice developments and legislative amendments, but starting with the SIPO update, we have good news from SIPO this year. Examination inventory has dropped by 42%, and wait times for registration for examination, have fallen to seven and a half or so months, which is clear evidence of restored operational capacity and success. And hopefully this means that as we emerge from the backlog triggered by a surge of filings after 2019, most marks filed in this new era have now moved through examination, and if not, are already advertised or registered. As you can see on the slide, filings in Canada remain strong at over 70,000 in 2025, and we saw notable growth in AI specifications. Canada, the US, and China continue to lead in both filings and registrations, followed then by Germany and some other regions in the EU and UK, where we also see strong filings. I'll hand it over now to my colleague Karl to talk about some of the key developments that we've seen, beginning with registrar-initiated Section 45 notices. Thanks, Karl.
Thanks, Toba. So, I'll be providing an overview on the new registrar-initiated Section 45 pilot project launched by the Trademark Opposition Board. So the purpose of this pilot is to improve the accuracy and the reliability of the Canadian Trademarks Register. So over time, many registrations remain on the register even when trademarks are no longer in use. So this dead wood can slow down trademark examination and create unnecessary barriers for businesses conducting clearance searches, and just create slowdowns during examination generally. So by proactively reviewing older registrations, the registrar aims to ensure that the register reflects marks that are genuinely in use and tied to the correct goods and services. So we can move to the next slide, please. So there are two phases to this pilot project, right? So in phase one, which began in January 2025, the registrar issued batches of Section 45 notices against randomly selected registrations that had been on the register for more than 3 years. So owners who receive Section 45 notices have 3 months to file evidence by affidavit or statutory declaration, which either demonstrates use of their registered trademarks in Canada during the 3-year period immediately preceding the notice, or evidence which explains special circumstances that excuse the lack of non-use during that time. So typically, once the owner files its evidence, Section 45 proceedings would then move to the optional written representations stage. However, for registrar-initiated Section 45 proceedings, the registrar added the step of reviewing the evidence, and it may offer to discontinue the Section 45 proceeding with the owner's consent, where the evidence provided clearly indicates that the trademark remains in use, or if the owner agrees to delete unsupported goods and services. So this modification to the standard procedure was implemented in the hope of ensuring a more efficient and cost-efficient process. So once a sufficient number of registrar-initiated Section 45 proceedings have concluded, then the pilot project will move to phase two, right? So in phase two, The outcomes of these proceedings will be studied to help inform whether the pilot should be expanded or adjusted. And so to do so, the Trademarks Opposition Board will organize public consultations to gather feedback on questions like whether there are particular types of registrations which should be targeted by this project, whether Section 45 notices should be issued against all or only some of the registered goods and services, and whether the registrar should perform a preliminary investigation against a selected registration and only issue a Section 45 notice if that preliminary investigation doesn't show any obvious use of the trademark in Canada. Next slide, please. So, as of this morning, we haven't seen much data coming out of the pilot project. However, we do have early results from January 2025, which shows that out of 100 notices issued, 54% of the registrations were expunged due to no response being received, while 36 were maintained. So 36 registrations were maintained and 10 proceedings were discontinued. So it'll be interesting to see what the later data shows and how that might inform the next steps for this process. But in the meantime, I will pass it over to Jennie for some updates on procedural enhancements to the Trademark Opposition Board.
Thank you, Karl. Next slide, please. So as of April 1st, 2025, new amendments to the Trademarks Act and trademarks regulations came into force following on the 2019 amendments. The Registrar of Trademarks has now new considerable powers to grant cost awards, confidentiality orders, and to case manage proceedings before the Trademarks Opposition Board. Starting with cost awards, the registrar may now award costs, but only in exceptional circumstances and upon request by the parties who must explain why costs are warranted. Cost awards are not intended to compensate the parties for their incurred costs, but to curb undesirable, unreasonable, or vexatious behavior or conduct in board proceedings. The relevant practice notice published by CIPO suggests that behavior or conduct that may warrant costs include where an application is filed in bad faith, and we will be discussing the bad faith ground later in our webinar, where a party withdraws from an oral hearing within 14 days of the date of the hearing, or where a party engages in unreasonable conduct that causes undue delay, complexity, or expense in a proceeding. The quantum of costs is prescribed by the amendments to the trademarks regulations and are fixed at multiples of the prescribed fee to commence a given proceeding, ranging from 2 to 10 times the prescribed fee, depending on the circumstances. So, for example, if a hearing request is canceled less than 2 weeks prior to the scheduled hearing date, the party that canceled its request may be liable for costs in the amount of 2 times the prescribed fee. So the prescribed fee for 2026 for commencing an opposition proceeding by filing a statement of opposition is $1,040. Multiplied by 2, that's $2,080. At the other end of the scale, if a trademark application is refused on the ground that it was filed in bad faith, the opponent may be entitled to a cost award of 10 times the prescribed fee. At the end of December, the Opposition Board issued its first decision in which it discusses cost awards. The citation is shown on the slide. This decision dealt with the cancellation proceeding before the board. Both the requesting party and the owner filed written submissions, but the requesting party's submissions included several citations that didn't stand for the principle that they were cited for. The board member states, at paragraph 25, these citations could be the result of an innocent mistake or lack of attention. They might also be the result of a failure to verify generative artificial intelligence work product, or even an attempt to mislead the board or other party. And then at paragraph 24, shown on the slide, if the owner had requested costs, I would have considered whether the inaccurate citations contributed to undue delay or expense in this proceeding. Costs were not awarded here as the owner did not request costs, keeping in mind that the registrar may not award costs of their own initiative. Other examples of unreasonable conduct which could lead to a cost award include breaching a confidentiality order or failing to declare or verify AI-generated content that has been filed with the board, both of which we will discuss next. Next slide, please. Turning to confidentiality orders, amendments to the Act and regulations also empower the registrar to issue confidentiality orders and to order that a proceeding before the board be case managed. The relevant practice notices are linked on the slide. The registrar may now issue orders to keep portions of evidence filed in a proceeding before the board confidential. Previously, all materials filed with the board were accessible to the public. It should be noted that even if both parties to a proceeding consent to a confidentiality order, such orders will be issued only in exceptional circumstances at the registrar's sole discretion, as confidentiality orders are viewed as a major departure from the open court principle. The registrar may now also designate a proceeding before the opposition board as a case managed proceeding, where the registrar will manage procedural aspects of the proceeding, such as by fixing the time or manner in which any step of the proceeding is to be completed. Next slide. Lastly, turning to another change relating to opposition board proceedings, specifically on the use of AI. When a document with AI-generated content is filed with the board, a declaration must now be included stating the AI was used and that the content has been verified by the party or their agent. Examples of documents that are considered to include content generated by AI are set out in the relevant practice notice published in June of this year and include written representations that are drafted with the help of AI, and search results or evidence that have been compiled with the help of AI. The practice notice also provides a sample declaration, shown on the slide, to be included in the first paragraph of each document in which AI was used. Over to Karl now to discuss the changes brought about the April 1st legislative amendments outside of the opposition board context.
Thanks, Jenny. So on April 1st, 2025, long-awaited amendments to Canada's Trademarks Act and Canada's Trademarks Regulations came into force. So as we'll see, key areas of focus of these amendments are discouraging abuse of Canada's trademark system and improving the efficiency of proceedings before both the Trademarks Opposition Board and the Canadian Intellectual Property Office. So starting with the introduction of Section 53.2, subsection 1.1 of the Trademarks Act. So this amendment introduced a new threshold requirement for trademark owners who want to enforce their rights in court. So specifically, if a trademark registration is less than 3 years old, the owner will now need to demonstrate use of the mark in Canada or show special circumstances justifying its non-use before a court can award remedies for infringement or depreciation of goodwill under sections 19, 20, or 22 of the Trademarks Act. So now what does this mean in practice? So essentially it closes the door on strategic filings by parties with no real intention to use the marks they register. We commonly refer to these entities as trademark trolls. So this new provision seeks to patch an issue arising from the 2019 removal of the use requirement for trademark registration that Toba mentioned at the outset. And the amendment also seeks to ensure that only legitimate brand owners can seek relief, such as damages, injunctions, or delivery of orders. So for brand owners, this underscores the importance of proactively documenting use early and consistently as part of a preemptive risk mitigation strategy. For defendants, it provides an additional safeguard against enforcement attempts based on unused or purely defensive registrations. So a lot of strategic considerations coming out of this new proof of use requirement. And if you're looking for any experienced counsel to navigate these strategies, our team would be more than glad to assist. So now moving on to the next slide. So now I'll talk about the leave requirement for new evidence on appeal. So again, as of April 1st, 2025, parties appealing a decision of the Trademarks Opposition Board to the federal court can no longer file new evidence as of right. So instead, they must now obtain leave from the court before any additional evidence can be introduced. So this is a major departure from the previous regime, where parties could hold back evidence before the board, knowing they could simply submit it on appeal. And Jennie just mentioned confidentiality orders, and this kind of works hand in hand with that. So a strategy beforehand would be to, not submit evidence at the board because you weren't able to get confidentiality orders for it. So you would just wait till you got to the federal court. Um, and but now that you can get confidentiality orders, that's no longer a concern. So this change is intended to create greater efficiency and promote fairness by ensuring that the best and fullest record is put forward at the board stage and not later. So interestingly, earlier this month, the federal court released its decision in Products Unlimited versus Five Seasons Comfort Limited, in which it engaged with the new leave requirement for the first time and provided helpful guidance on factors to consider when deciding whether or not to grant leave. So I won't go into the nitty-gritty of this decision, but interestingly, or notably, the relevant considerations include the relevance, credibility, and admissibility of the evidence, the materiality of the evidence, the circumstances surrounding the delay in filing the evidence, and whether granting leave could cause prejudice to the opposing party. So this framework really underscores the key message that parties must be proactive and strategic at the board level, and they must be prepared to explain why any new evidence wasn't available beforehand. So ultimately, this shift reinforces the value of thorough preparation and experienced counsel. Once again, sorry for the shameless plug, early in the process. And so by treating board proceedings as the primary forum and not just a preliminary steps, parties can avoid unnecessary hurdles and position themselves for a strong appeal if one becomes necessary. Next slide, please. Okay, so now for a fan favorites, official marks. So as many of you know, official marks have long been considered super marks under the Trademarks Act, speaking informally, of course. So official marks can be any badge, crest, emblem, or mark adopted and used by a public authority in Canada. And once the registrar provides public notice of the mark, third parties are essentially adopting or using the mark for any mark so nearly resembling the official mark, such that it's likely with the official mark. So now, unlike ordinary trademarks, official marks are not limited to any particular goods or services, and historically they've been very difficult to challenge or invalidate. But recent amendments have changed that. So new provisions in the Trademark Act, specifically subsections 9.3 and 9.4, introduced a mechanism for challenging official marks. So again, as of April 1st, 2025, any person can request that the registrar publish a notice that the prohibitions on the adoption and use of an official mark no longer apply if the holder isn't a public authority or no longer exists. So once the fee and the request are received, the registrar screens the file, and if it's warranted, the holder of the official mark is notified and asked to submit evidence of its public authority status within 3 months. And an interesting point is that the registrar can also initiate this review on its own initiative. So if the registrar concludes that the holder of the official mark is not a public authority or no longer exists, the registrar may issue the public notice that the protection tied to the official mark no longer applies. The mark is then effectively inactivated unless that decision of the registrar is overturned on judicial review. So an interesting point here is that the practice notice on this amendment is that an official mark holder who doesn't respond to the notice or doesn't provide satisfactory evidence in response to the notice. So in those situations, the registrar will send on its own initiative a notice to that holder requesting evidence of public authority status for all official marks under its name. So for businesses and trademark applicants, these reforms open the door to clearing out obsolete or unjustified official mark barriers which previously blocked registrations or required negotiating consent from public authorities that may no longer have been active. But for current official mark holders, this change is very important to take note of because it sends a clear message that now's the time to review your portfolios. And if your status as a public authority is potentially vulnerable, you may want to consider filing new applications for ordinary trademarks to preserve your rights. So with that, I will now pass it over to Toba.
Thanks, Karl. We're going to take a look now at our second sort of major theme from 2025, which our group consider to be helpful lessons from the Trademark Opposition Board. If we move to the next slide, you'll see an uptick in anticipated numbers. And so I guess as predicted in 2014 by the senior members and most keen members of the IP bar, oppositions and Section 45 activity continues to climb, both with categories showing meaningful increases compared to the 2018-2019 cycle. The number of statements of opposition filed in that, the increase, I should say, of the number of statements of opposition filed since 2018 is up by 44%. And an increase of about 17% with respect to Section 45 notices. And I think considering everything you've heard thus far and how we see practice changing and playing out, it's fair to say that we can expect this upward trend to continue. If we move to the next slide, we will briefly talk about two other key lessons from the 2025 board decisions. So our group, with the help of our Toronto office's amazing articling students, took a look at the almost 300 decisions rendered by the board in 2025. And we were keenly aware of two themes that stood out that provide two really, we think, helpful lessons. The first being that procedural rigor is not optional, and adherence to the fundamental principles of evidence is becoming increasingly crucial for the maintenance of rights. As we see every year, many expungement decisions turn on the quality of the evidence and whether it truly shows use. But since Section 56.5 has come into force, the decisions related to summary expungement, they read a bit differently now. The risks tied to defective records, weak affiants, procedural lapses, they're all now higher than ever. Bad evidence on the first kick at the can have significant consequences. And the lesson, it comes to portfolio management and maintenance, registrants who want to retain clear, contemporaneous evidence of use, which can ultimately be adduced by first-hand affiants, those are the registrants that will increasingly have the advantage. In our second column here is our second lesson. As cancellation and opposition activity increases and with no use requirements at filing, The 2025 board decisions also illustrate how considered and thoughtful trademark application drafting can be leveraged to avoid unnecessary vulnerability. The decisions coming from the board that turn on this topic or address this topic, they demonstrate that goods and services are construed literally and structurally, not commercially or sympathetically. In a system where you don't need to use it to register it, but you do need to use it or lose it, decisions made while drafting applications can actually be determinative. And so the lesson, those who draft applications with the specifics of the applicant's current and future business goals in mind can best safeguard their rights in the short term and in the long term. In particular, in this new regime where the registrar may on its own be able to initiate a cancellation proceeding. While we haven't cited the cases on the screen in our paper or article, we have included them here for your reference. I'll hand it back to Jennie now to discuss what we've learned this year about special circumstances excusing non-use.
Thanks, Toba. Next slide, please. The next thing we will look at is the special circumstances test that excuses non-use of a registered trademark in a cancellation proceeding pursuant to Section 45 of the Trademarks Act. That test is now the subject of a Federal Court of Appeal decision issued in 2025. A cancellation proceeding is commenced when the registrar issues a Section 45 notice to the owner of a trademark that has been registered for a period of 3 or more years. We touched on this topic in our earlier discussion on registrar-initiated Section 45 proceedings. These proceedings can also be requested or initiated by a third party. So recall that the Section 45 notice will require the owner to demonstrate one of two things: either use of the mark during the 3-year period immediately preceding the issuance of the notice, or special circumstances excusing non-use in order to maintain the registration. Where there has been a recent change in the ownership of the mark, the period of time that is examined for determining whether special circumstances exist is generally the date the trademark is acquired by the new owner. So the new owner would need to establish special circumstances from the date of acquisition to the date of the Section 45 notice, but would not need to excuse non-use by the old owner prior to the acquisition. The string of case law relating to that specific circumstance of a recent acquisition of a trademark that is subject to a cancellation proceeding is referred to by the Federal Court of Appeal in the next case that we will discuss as a new owner jurisprudence. Next slide, please. The Federal Court of Appeal decision in Centric Brands is the first time the court analyzes in depth the new owner jurisprudence. Briefly, the facts of the case are as follows, and dates are outlined on the slide. Centric signs a purchase and sale agreement on June 27, 2018, in which they acquire, among other trademarks and subject matter, a registration for the trademark Averix. The transaction closes and the mark is assigned to Centric on October 29th of that year. In the meantime, on October 12th, just days prior to closing, at the request of a third party, the registrar issues a Section 45 notice against the Averix registration. As the new owner of the mark, Centric responds to the Section 45 notice, relying on the recent acquisition and on the new owner jurisprudence to excuse non-use. The registrar rejects this argument and orders the mark be expunged. That decision is upheld on appeal to the federal court on the basis that since the acquisition closed after the notice issued, Centric was not a new owner during the 3-year period preceding the issuance of the Section 45 notice, and therefore the new owner jurisprudence didn't apply. Now, up to this point, all of the new owner jurisprudence, or nearly all of it, dealt with the change in ownership that took place during the relevant 3-year period. And the Federal Court of Appeal had also previously commented that transactions taking place after the notice issue should be viewed with some skepticism. In Centric Brands, on appeal to the Federal Court of Appeal, the federal court's finding was rejected as an error of law. The Court of Appeal found that the new owner jurisprudence could apply where a purchase and sale agreement had been signed but not yet closed during the relevant period, and that the federal court erred by requiring that the acquisition be fully closed before the Section 45 notice issued, as that approach turned on the chance issue of the date the parties chose to close a transaction that had been arranged months before. the court confirmed that such acquisitions may constitute special circumstances, provided they are genuine arm's-length transactions. So the relevant period here for considering special circumstances was the 3.5 months from the signing of the purchase and sale agreement to the issuance of the Section 45 notice. The key issue in all Section 45 proceedings is whether the trademark should be considered dead wood. On that point, the court noted the acquisition itself of the mark as part of the transaction suggests that it was not deadwood. It suggests an intention to commence use of the mark. The court emphasized that while Section 45 is designed to clear deadwood from the register, it must also allow flexibility for legitimate commercial dealings. The Court of Appeal was also concerned that the federal court's ruling could invite mischief in that a third party could request that a Section 45 notice be issued once a trademark acquisition is publicly announced, but before the acquisition has time to close. So the Court of Appeal set aside the expungement, finding that the recent acquisition and the brevity of the relevant period, which was just 3.5 months, constituted special circumstances. The general rationale behind this being that the new owner of a newly acquired trademark would likely need some time to make arrangements to use that mark. So that summarizes the case on where the new owner jurisprudence currently stands. The respondent has sought leave to appeal the decision to the Supreme Court, so we may see more on this topic. Over to Karl now to discuss an opposition board decision that also deals with the new owner jurisprudence.
Thanks, Jennie. So I will be discussing the opposition board decision in Smart for the Société des Produits Nestlé SA that highlights the limits of the new owner jurisprudence and reinforces the need to submit substantive evidence when claiming special circumstances to excuse non-use of a trademark. So in this case, the registrar issued a notice under Section 45 to Nestle regarding its trademark Seattle's Best Coffee design, which is depicted on the screen. So the notice was issued March 28th, 2024, following the request of Smart Sweets. So the mark had been acquired by Nestle on January 13th, 2023. So roughly 14 months before the notice, before the notice was issued. Next slide, please. So Nestle was able to demonstrate use of the mark in Canada for some coffee-related goods, including ground and whole bean coffee, espresso beverages, commercial espresso machines, etc. However, its evidence did not address many of the other non-coffee related goods and services listed in its registration, including vending machines, baked goods, soft drinks, tea products, etc. So to fill this gap, Nestle argued that its recent acquisition of the mark, its status as a major multinational company, and the short amount of time left in the relevant period, and so again, that was around 14 months, constituted special circumstances excusing non-use with regards to the non-coffee related goods. So the Trademark Opposition Board did not agree with Nestle. So while it acknowledged the Federal Court of Appeals guidance in Centric, which Jennie just overviewed for us, so while it acknowledged Centric and the principle that a recent acquisition can be relevant, the board reiterated that acquisition alone is not determinative. So in Nestle's case, the evidence relating to special circumstances consisted almost exclusively of the fact of acquisition alone. So there were little to no details about the nature of the transaction, operational constraints, or any concrete barriers preventing use. So the board found that Nestle didn't provide details or explanations regarding the period of non-use, which lasted over a year, and it also didn't demonstrate any serious intention to resume use of the mark for the remaining goods and services, the non-coffee related goods and services. Now, an interesting point too was that the board considered the fact that Nestle was able to begin using its trademark immediately for the coffee-related goods and services also suggested that the non-use for the non-coffee-related goods wasn't due to circumstances beyond Nestle's control, but rather it was a result of a voluntary decision to prioritize certain goods over others. So ultimately, the board concluded that special circumstances were not established, and ultimately the registration was amended to remove those goods and services for which use was not demonstrated. So overall, this decision underscores that new owners can't simply rely on the fact that there was a recent acquisition of the mark. They must still provide meaningful, detailed evidence or of the genuine commercial plans of their genuine commercial plans if they want to preserve unused portions of trademark registrations. So now I'll pass it over to Toba. You're
On to our first tech error there in the whole webinar, not bad. We're on to our last theme here for the webinar today, and that's the evolution of bad faith. I know a topic that a lot of us watch pretty closely. We can move to the next slide, Kwan. Thanks. Before we get into the 2025 decisions, I'll take you back for a minute to the 2019 amendments, where the concept of bad faith was expressly incorporated into the Act, both as a ground of opposition and as a ground for invalidating a registration. But bad faith was not expressly defined. And so since then, the board and our courts have been shaping the boundaries of bad faith. To date, factors informing the bad faith analysis have included whether at the date of filing, adoption of a mark was done with knowledge of the senior rights holder, whether there was a pattern of troll-like behavior, whether there was any demonstrably legitimate intention to use the mark, etc., and some other considerations are there on the slide. Courts have since held that bad faith is not limited to dishonest conduct. It extends to actions that fall outside generally accepted standards of commercial behavior, but does not extend to behavior that follows an initial good faith filing and involves considering applicants' subjective intention at the time of filing. We can move to our 2025 textbook case of bad faith. Actually, a successful case by a team here at Smart & Biggar. In Snap and Ghostface Chilla, the applicant sought to register Ghostface Chilla for clothing and retail services, despite Snapchat's long-standing use and public association of its ghost mascot with that same name. Depiction is there on the slide. Application was filed by an entity called Ghostface Chilla Inc. Its principal had a documented history of infringing activity, and the opposition focused on bad faith, in addition to non-registrability, non-entitlement, and confusion arising from the applicant's deliberate linkage to Snapchat's marks. Evidence showed years unauthorized merchandising, domain hijacking, social media posts presenting the mark as the official Snapchat mascot. Those same actions, of course, drove the confusion assessment, as the applicant repeatedly tied the mark to Snapchat's goodwill in order to purposefully mislead consumers. The board found this pattern, combined with extortionate sale demands and persistent misuse, to be egregious, a textbook example of bad faith filing, and of course refused the application. This is likely one of the first bad faith opposition decisions where the factual record amounted to what we read as like a full catalog, or almost like a laundry list of potentially independently sufficient bad faith indicators, though that hasn't been confirmed. With conduct of this magnitude, it was virtually impossible for the applicant meet the onus of showing the filing was not made in bad faith. While Ghost Face Chilla is certainly a very useful precedent and, as I said, a notable success of our firm, it does only a little bit to clarify how bad faith should be assessed, and certainly not a whole lot in the far more gray or common cases. Beyond the uniquely clear facts in Ghost Face Chilla, 3 2025 decisions help illustrate how bad faith is assessed in a more typical, nuanced opposition and invalidity context. Each of those cases, which I'll discuss just now, add definition to our existing list of factors to be assessed when considering whether there was bad faith at the time of filing. So where are we today in terms of the more borderline cases? We have a little bit of additional clarity. In the first case, in the first column there on the slide, TMOB 134, the board found bad faith where the applicant had previously filed trademark applications containing one particular translation for Ong To, which hopefully I'm saying correctly, and only after receiving an objection on examination, filed a further application for a mark containing that same element, but with a different translation of the same words, Ong To. The board considered whether that shift was intentional manipulation, and the board held that it was. In this case, because the applicant offered no credible explanation. So this case is helpful in the sense that it gives us another example of where the grounds are rightly put in play and we have no credible explanation to the contrary of the facts presented. We could find bad faith, although I do query whether a slight change in the facts of this case where a credible explanation was perhaps provided, whether this case would have landed the same way. In TMOB 166, the dispute centered on indigenomics, where the applicant showed long-standing independent use of the term, wasn't exactly clear on the facts whether it was necessarily trademark use or not. That aside, the board concluded that there was no deception or manipulative conduct in this case, and so bad faith was dismissed. And finally, in the federal court decision, FC 1864, the court reaffirmed that bad faith, and in this case, in the context of invalidity, requires clear, persuasive evidence of intent. Questionable market behavior will not be sufficient to mount a case in bad faith. I think taken together, the decisions show a maturing jurisprudence and definition, and certainly demonstrate that an evidence-based approach focused squarely on conduct and the mental state of the applicant are going to be relevant considerations. That actually brings us right on time to our closing remarks. As we close on the developments from 2025 that we've elected to discuss today, we reflected as a group on the fact that 2025 provides a sort of measured snapshot of how the post-2019 trademark framework is operating across a range of ordinary cases. The decisions and practice changes we've discussed reflect a shift in application of familiar principles under a modified statutory structure. At the same time, they help set the context, we think, for the years ahead, as legislative amendments begin to inform day-to-day practice, and also as rights holders continue to respond to broader economic pressures and an increasingly complex commercial landscape. We see tremendous opportunity arising from the 2025 updates for rights holders in Canada. Some of the lessons from 2025 can be employed, for example, to improve portfolio management and improve what I like to refer to as portfolio hygiene. The options now available because of procedural updates can be leveraged by Canadian rights holders to create practical and cost-efficient approaches through case management, perhaps by consolidating multiple proceedings to limit duplicative evidence preparation, as an example, yet to be tested. We're hoping that confidentiality orders may enable the more concrete protection of confidential business information while engaging in board proceedings, allowing parties who may otherwise hesitate to fully participate to do so without reluctance. And since the end of the pandemic, we are seeing a massive spike in M&A activity in Canada. Clarification around the new owner jurisprudence will be helpful to companies who may be considering or are in the process of acquiring dormant or semi-active portfolios. We think that 2025 is sort of best understood as a year that clarifies where the system stands and how it's positioned to respond as these conditions continue to evolve. And I think that brings us to our Q&A.
Perfect. Thanks, Toba. What a fantastic discussion. Lots of different themes, lots to think about. Certainly one of those more interesting years that we have in Canada on the trademark side. So that brings us to the Q&A portion of the presentation today. We'll be looking at some of the questions that have come in. And also remember, you can continue submitting your questions via the Q&A panel at the bottom of your screen. So let's begin with the first question we have here. And this question is, are domain name decisions from the UDRP or CDRP helpful in trademark bad faith arguments?
I can take a stab at this one, having ongoing dealings with this exact question. The answer is yes. In particular, where there is a pattern of troll-like behavior with a series of successful CDRP or UDRP decisions. And that actually can be employed strategically for the same purpose.
Great. Okay, thanks, Toba. We'll go on now to the next question, which is, how do the registrar-initiated Section 45 proceedings compare to third-party initiated Section 45 proceedings?
Right. So the registrar or the board has a few procedural differences between both registrar initiated Section 45 proceedings and third party Section 45 proceedings, but they're very minor. So the main difference, in my opinion, is that in straightforward cases, the registrar may offer to discontinue Section 45 notices with the owner's consent, where the owner provides satisfactory evidence that the mark is clearly in use, right? So that's one difference. But then also in terms of scheduling, so at the at the registered owner's election, a hearing can be scheduled at a mutually beneficial time, right? Whereas there's a bit more red tape around scheduling a hearing if third parties are involved. So those are two procedural differences. But now, interestingly enough, too, we have received some statistics on the board has compared statistics from January 2025. So I mentioned the ones beforehand for registrar initiated Section 45 proceedings, but we also have some data on how that compares to third-party initiated Section 45 proceedings. And I won't go into the nitty-gritty of it, but a main difference is that we're seeing a higher percentage of registrations being expunged through third-party initiated Section 45 proceedings. And we're also seeing a higher number of registrations maintained through third party, or sorry, registrar initiated Section 45%. So that's just some interesting statistics there.
Great. Thanks, Karl. Thanks for that very detailed answer. Okay, next question is interesting and brings up a topic that comes up very often these days. So the question is, with the changing AI landscape, how do we best protect clients when purchasing trademarks that may have been created with AI or use AI when creating the trademark?
Maybe I can speak to this one as well. Something that comes up, unfortunately, quite frequently in my practice. And it's a great question, and thank you. Diligence and clearance is the short answer. If proper diligence is completed, using clearance strategies at the diligence stage or earlier in an ideal scenario, then risks associated with those AI created marks, whether they be copyright related risks or others, like marks that have already been adopted by others who maybe used the same AI tool to build the same mark, those can be captured early in the process of an acquisition and then mitigated as necessary. So hopefully it's a pretty short answer, but to a very big question, but hopefully gives you a sense of how diligence and clearance play an important role there.
Thanks, Toba. We could probably spend a whole hour separate webinar talking about AI, but we'll leave that maybe for some other time. Next, we have a question about confidentiality orders. So the question is, can an applicant request a confidentiality order for evidence filed with the Trademarks Office during examination outside of an opposition proceeding?
I can take this one. I think the question relates to any affidavits that are filed with the Trademarks Office by an applicant to show use of the mark and that their mark has acquired distinctiveness to overcome a distinctiveness objection. So the answer to that is no. Confidentiality orders are currently available before the opposition board only.
Great. Thanks, Jennie. I know we're getting close to time here. So we've got one more question here, which I think we can take this one just briefly before we wrap it up. So the question here is just regarding official marks. Regarding the new mechanism for challenging official marks, how is public authority status determined?
I can take this one. So the Federal Court of Appeal had released a decision, I think back in 2002, between the Ontario Association of Architects and the Association of Architectural Technologists, I believe. And that essentially sets out the two-part test for determining public authority status. And the two considerations are, whether a significant degree of control is exercised by the relevant or the appropriate government body. And the second consideration is whether the activities of the body benefit the public. So if there is significant control by a government entity and there is public benefit, then typically that would lead to the conclusion that you do have a public authority, and that's the test that that's going to be used to evaluate the public authority status.
That's great. Thanks, Karl. And so with that, we've reached the end of our Q&A session today, right on time. Thank you so much, everybody, for your participation today and your insightful questions. Those are great. As a reminder, when the webinar ends today, a survey link will pop up on your screen. Please do take a moment to share your feedback. We really do appreciate it. Just looking ahead, if you'd like to join more of our webinars, we invite you to subscribe to receive our updates, and also keep an eye on the events section of our website. We'll be sharing more webinars this spring and details will follow. Just a quick note, as you can see on the slide here, this webinar may be eligible for continuing professional development CPD, or continuing legal education, CLE credits, subject to the requirements of your governing body. That information is shown there on the slide. And that's it. Once again, thank you very much for taking the time and joining us today. And we really hope to see you at our future sessions. Take care, everybody.